Smiling if you
And-
move a memo, what is the
And
stage?
we are also partly the cause of irritation because we have held up your lordship's busy court.
That's my lord. Right now, my lord,
No, that's precisely the reason why I have not got all the matters listed today and
know.
postponed it to Monday.
my lord, I admit the guilt.
Your
admit
lordships
the
have been
guilt.
so kind to us.
Yes.
My
So
lord,
that
my lord, yesterday I thought that my submissions were over, and I have been able to convey, my lord, what is the case of the government.
yes, sir.
But my lord, there are certain issues which I would like to highlight,
Yes, sir.
and therefore to recalibrating my submissions, my lord, I requested for
Oh,
today.
no issue.
The reason is this, my lord, and I'll be very candid with your lordships. What is the reason? Lord, after the Renault judgment and after advent of internet and its progress, which we have seen, there is no judgment of any Indian court which takes into consideration the progress made by internet, its pervasive impact on the society's thinking process, society's values, societal values, etc. No judgment has taken care of the algorithms which are used for the purpose of content curation and kind of, my lord, an editorial intervention indirectly, may not be human intervention, but by machine. And my lord, collection of metadata of individuals and their submission that now we are still not touchable. We cannot be touched. We can touch private information, personal information of individuals and curate our content, but we cannot be asked. Another question, my lord, which may, my lord, be a relevant factor is your lordships have seen in the judgment of the Supreme Court of US that even US Supreme Court complains that they don't share their algorithms even with the Supreme Court of US.
Yes.
They are based in US. They are governed by laws of US. Third, similar safe harbor provisions with similar exceptions, exception to exceptions, exist in almost all jurisdictions in the world, where all intermediaries are following, and this is the only one social media intermediary, Lord, which has a problem and which is before the court.
Yes.
Now, your lordships may take my written submissions,
Yes,
and
sir.
I will skip most of it.
Yes, yes, no problem.
My lord, when
No, you can go at your pace, sir. No
no, my
problem.
lord, when my lord, a person argues before the honorable judge for more than half an hour, but he knows, my lord, what to argue, what to skip, and arguing basic points before a particular judge
Yes.
is almost contemptuous. That means that you know that the judge would not understand. I know, my lord, your lordship's grasp is much faster than, my lord, our grasp. I'll leave that, my lord. Kindly come to page 30. I'll leave most of the part. I'll just highlight what are the broad propositions with which I would like to assist the court, my lord.
And I will definitely go through everything and then.
I am very sure about it. Therefore, with that assurance which
Yes,
I have
yes.
given to myself, my lord, I am skipping. My lord, kindly come to page 30, para 67,
Yes, sir.
just to take, my lord, the thread from where I left.
Yes, sir.
Further, the European Union's regulatory response has recently culminated in the Digital Services Act, effective 2024. The DSA retains the basic safe harbor for mere hosts, but adds significant due diligence obligations, especially for very large online platform. What we in our law say, substantial, not significant social media intermediary. It is, I'm thankful. It is submitted that under the DSA, platforms above a certain size must proactively assess systematic risk on their service, such as dissemination of illegal content, impacts on fundamental rights, electoral manipulation, etc., and put in place reasonable mitigation measures. It explicitly allows courts or authorities to issue orders to remove illegal content and even expect quick compliance. We're not posing here only for a minute. In one of my, my lord, one of the paragraphs of my judgment, my lord, I have said that Shreya Singhal does not lay down the correct law, to which the answer of the other side is legally absolutely a correct, right? That can never be argued before the Honorable High Court, because your lordships cannot say. But nonetheless, I have retained, my lord, that submission, so that eventually, my lord, I may request, my lord, a bench of larger combination to reconsider Shreya Singhal
There.
there.
Yes, yes.
Not here. I'll not argue that here. But my lord, that's the reason. You are absolutely right that that cannot be argued here, and I'm not going to argue it here. But I have to place it, my lord, in the pleadings before the High Court, and we may request, my lord, the Honorable High Court to consider maybe in a three-judge bench combination that what it was in 2014 and other factors, my lord, I'm not going into. Now, please come to page 31. Lord, these are the facts I have given
Yes.
as per the available documents with us. I'm not reading them. What it is, my lord? What is the uh, compliance of X, the petitioner before your lordships, in other jurisdictions? In some of the jurisdictions, they have imposed fines, they have filed an appeal, they are censured. Some of the jurisdictions.
Stop, my learned friend. I just want to make one point.
No, no, I'm coming to that. Please give me a minute.
Para
This-
69 is part of the written submissions,
Huh.
but they're not pleaded. So, I mean, if you just simply say you have been censured by that court, I don't know what happened in that court. Then,
No,
my lord, if
it is said appeal is also filed against the order in the
but
other
I,
column.
my lord, I don't know what order has been passed. I don't know what was the context. So, my lord, I just want to
You can
take
reply.
that fact because to
You
make
can-
an insinuation against my client in a written submission on facts, I mean, all about Reno, subsequent development of the law, of course, my lord, learned solicitor is perfectly justified. But to make an insinuation against my client,
No, you can
that-
reply.
My lord, my learned friend is absolutely right. These are factual assertions
Yes, yes.
and must come in the pleadings and not in the written submissions. But I have placed, my lord, only to show that there are intermediaries who are not complying with the guidelines, and to my lord, forget X, to show to your lordships that there is a concern of every jurisdiction, every country is grappling. I have given instances of X, but I can give instances of, my lord, other intermediaries also, but I didn't want to burden that any deviation from, my lord, the exception to safe harbor, like, Lord, taking care, due diligence, etc., is viewed very seriously now by almost all jurisdictions. I leave it at that, my lord. I'm not reading it. Lord, now please come to, my lord, the head at page 33, and I'm not going to read this heading. My lord, all contents on the intermediaries is not relatable to
19.
Article 19(1)(a). My lord, all companies have their Twitter accounts, X accounts. My lord, now we are accustomed with the word Twitter. My lord, they propagate their, my lord, idea of their policies, their progress, etc., These are all advertising Twitter accounts. Many of them would be advertising, and therefore, my lord, commercial speech is, my lord, very, very restrictively protected by 19(1)(a) rights, my lord. That's what I have said. Now directly come to, my lord. My lord, I have given the judgments. I'm not reading the judgments.
Yes.
Now, my lord, the next point. Let us see, my lord, on the brass facts of this case. What is under challenge is Rule 3(1)(d). Rule 3(1)(d), the last part. Last part says, whatever is unlawful, you are cautioned, you are not punished, you are not directed to take them. You are cautioned that this is unlawful. The remedy is not to challenge 3(1)(d). If they are aggrieved, they will have to challenge the law which makes it unlawful. I'll give an illustration. My lord, I'll just read, my lord, D1 once again, my lord.
Yes.
An intermediary on whose computer resource, I'm sorry, my lord.
Yes, sir. 3(1)(d).
Yes, my lord. Any intermediary on whose computer resource the information is stored, hosted, so and so, so and so.
Yes.
Kindly come to the last line. Or any information which is prohibited under any law for the time being in force. Suppose I'm giving an illustration in, say, Copyright Act or Trademark Act, there is a prohibition that nobody would use the trademark which is registered in my name. It's prohibited to use it by anyone else. So it would be something if, my lord, some Twitter user publishes my registered trademark or something which is a copyright of mine, my lord, on that in his Twitter account, and I caution him. What I do is I notify him, the Twitter, that this is prohibited under law, particular law. If they are aggrieved, they can say that that provision is unconstitutional. It can be published. Either user can say, or if they are aggrieved, they can say. But you can't shoot the messenger. You can't say that, no, don't even inform me what is prohibited by law. I'm putting a question to myself, my lord, can the government, by making statutory regulations, not have a provision to inform them that this is something which is prohibited by the law of the land? How can, my lord, I'm posing a question to myself, that become unconstitutional? You challenge that law. Suppose, my lord, there is a law that nobody would criticize the government of the day, hypothetical law, and somebody puts a post, my lord, criticizing the government of the day. They can very well challenge that law, but not 3(1)(d). 3(1)(d) is a generic provision. Anything which is contrary to law will have to be informed. But now, please come to page 42.
Yes.
And again, my lord, I'll skip what is not necessary, my lord.
Yes.
But my lord, two judgments came immediately after the constitution came into force.
Yes.
One was Ramesh Thapar and another was Brij Bhushan. My lord, what was the ratio of that judgment? If I were to say in one line, the ratio was that Article 19(2), which provides for reasonable restrictions, are to be strictly construed.
Construed.
There is no elasticity. And the parliament was acting, your lordships are aware, till, my lord, the first election took place.
Yes, yes.
The first parliament was also acting as constituent assembly. So first parliament, acting in its capacity as a constituent assembly, said that now because of these two judgments, and they discuss the judgments, both the judgments, they say that we will have to do something about it, because there may be situations where a particular instance may not fall within strict four corners of the, my lord, contingencies given in 19(2). It may not be sovereignty of India. It may be something relating to that. It may not be public order, something relating to that. And therefore, my lord, I have given, my lord, the debate. Debate is 900 pages. So I have been selective, my lord, in giving the debates which is relevant for the present purpose.
Yes.
But please, my lord, come to what Prime Minister Nehru says. Two or three, my lord, I'll just read for my satisfaction.
Yes.
At page 44, the Prime Minister and Minister of External Affairs, we have come up here naturally because after the experience of a year and a half or so, we have learned much. We have found out some, if I may say so, errors in drafting or in possible interpretations to be put on what we have drafted. That is but natural. And the House will also remember. Then, my lord, kindly see the Dr. Ambedkar. I'll skip that. Your lordships can read it at leisure.
Yes.
Detention laws are something quite different because Ramesh Thapar, etc.,
Yes.
dealt with that. That is in nutshell, Sri Kamath, what a poor nut. Sri Kamath must have said something and everything was get recorded. And in the entire debate,
Yes.
Mr. Kamath and Dr. Ambedkar were opposing each other.
Yes. Yes.
And Mr. Kamath was a little more vocal about his personal
Views on that.
views on
Yes.
the individuals.
Yes.
The case for amending Article 19 of the Constitution. It is next important to consider why the Supreme Court and various state high courts have come to this conclusion. Why is it that they say that Parliament has no right to make a law in the interest of public order? But in the interest of was not the word in the original section.
Yes.
And that they are introducing. In the interest of public order or in the interest of preventing incitement to an offense. That is a very important question. And it is a question about which I am personally considerably disturbed. For this purpose, I must refer briefly to the rules, etc., etc., my lord. Now, please come to, my lord, page 45, only bold part.
Yes.
How has this happened? This has happened because US Supreme Court, although it was the first court in the world which was called upon to reconcile the fundamental rights of the citizens with the interest of the state, after a great deal of pioneering work, came upon